Hey out there, legal warriors. If you get served with a restraining order in Washington state, it may have child custody issues. I hope it doesn't, but if you've got children, so many people do, and you get served with a restraining order from the other parent, it can be a real nightmare. So I'm going to cover some things you need to know about this situation, things that will help you. So stay tuned if you're interested in this area of the law. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm has been defending people charged with crimes all throughout Washington state for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now I'm just going to jump right into it. We're a criminal firm, right? We also defend and try to get, but mainly defend protection orders for people, and that's what we usually call restraining orders. The same word, the law says protection order, but the public calls it restraining order. And for domestic violence restraining orders in particular, out of a civil matter, not out of an arrest, where one parent is basically going after an order against the other parent, oftentimes it will list the children as a protected party for this emergency temporary order. And when it does list them in the order, that means that custody of any child listed has basically been taken away from the respondent, from, in this situation, the hypothetical, the other parent. And that doesn't really seem fair, because all of a sudden your kids are missing based upon an ex parte, a one-sided petition where the petitioner goes in without having to prove anything, without notice to the respondent, and says, the respondent committed acts of domestic violence. I want a protection order and I want the kids listed on it too. And it doesn't even have to be any type of alleged violence versus the kids to get the kids on the order. That temporary order can also give control of the home, and it often does. The family residence goes to the petitioner. Cars, pets, all types of things go to the petitioner. And from the respondent's point of view, doesn't feel very fair. They're thrown out their house. They don't have any kids. They don't know what to do. So in this situation, what we have to do is not panic and realize that this is a temporary order. It's still very bad. It's a temporary order that's typically good for 2 weeks, and there's going to be a return date where you have a chance to fight about this. And the return date's going to be on the temporary order. You're going to get the temporary order and the petition. You need to read the petition and see what's in the petition that is justified a judge granting a temporary order. And then you need to reach out to an attorney to get some help. Now, unfortunately, the new law, it's July 2022, I'm filming this July 2023, so it's a year old, but it's still new to us in the business, has a very broad definition of domestic violence. So I want you to take a look at that definition in the paperwork you're served, or you can look at it under RCW 7105, but it doesn't even require actual violence. Subjective fear on the part of the petitioner may be enough to grant an order. There's something also coercive control, asking where someone's going, tracking them, things like that. Lots of very broad definitions that can justify an order. So it's an uphill battle that you need to take seriously. Sometimes the best move, if you've also can fit your life into a victim under these broad definition of domestic violence, sometimes it's a good idea to go get your own petition for your own DV protection order against your spouse who did it against you, so you can get your own order going, so you at least got equal petitioner benefits under the law, because this law benefits the petitioner at a horrible disadvantage to the respondent. So the part that we really have to wrap our head around is, at this type of hearing, even though child custody is involved for this order, they're not looking into the best interests of the child. It's not like a parenting action or a divorce. Now, I don't do family law. I'm no expert, but I'm involved enough of these to see the differences. So at the full order hearing, you're going to file a response. You're going to do what you need to do to try to fight this thing. Maybe you filed a petition, so you've got a petitioner benefit as well on another hearing. But the judge isn't going to decide who the best parent is. At the full order hearing, the judge is going to decide whether or not the petitioner, or either petitioner, has met his or her burden in showing that they've been a victim of domestic violence at some point during the relationship, even if it was 5 years ago or 10 years ago. It's just crazy how broad this definition is. And in most cases, the petitioner is going to be granted their relief. And in some cases, the court will actually then do like a temporary, visitation schedule or stuff like that. Depends on the county. So it can get a little family law like where you might get some relief, but a lot of courts will just leave it blank and they're going to stamp it and says anything I order here vis-a-vis the children is subject to being modified in a RCW 26.09 or other parenting action. So that's why we don't panic totally, because if your kids are taken away and you lose this permanent order, which means 1 year or more after a hearing, doesn't necessarily mean you're not going to see your kids for a year, but it may mean that if you don't go find yourself a family law attorney to start a parenting action where we can get the best interest of the kids taken into account, amongst many other things, who's had primary residential care and custody. Again, I'm no expert in that, but the court will look at other things than just besides the issues under 7105, which is just the broad definition of domestic violence. So you don't give up. If you lose that hearing, you got to go immediately find yourself a family law attorney. They're hard to find them. They're hard to find. And try to get something going where you can get some rights to see your children, because the 7105 does not trump, the restraining order law does not trump the parenting action. It's the other way around. Okay, it's the other way around. So it's not fair and to the person who's getting the kids taken away. It's very fair to the person who feels they need the protection. It depends on your point of view. But I want you to know, if you are in this situation where your kids are gone due to this restraining order, that you need to fight that hard. You think about becoming a petitioner yourself, and then you definitely think about getting that family law side going so you can get different issues that are less of a disadvantage to you, to trying to get to see the kids you care about so much. So I hope you found this useful. If so, please like and please subscribe. More people get the help they need. And more importantly, if you have a criminal problem or a restraining order problem, feel free to give my office a call. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.